My name is Simon Lawson, Chief Executive at Citizens Advice Richmond. We offer a range of activities that are funded by Richmond Council to help EU citizens deal with Brexit and its aftermath. We offer webinars, presentations, talks and one-to-one advice. I'm now going to hand over to our expert advisor who is going to present this evening's presentation.
My name is Mike Harron and I'm the EU caseworker at Citizens Advice Richmond. So I advise EU citizens on settled status, the settled status scheme, on nationality applications by children and adults to become British citizens, and also your rights in the UK following Brexit. I'll spend most of the time talking about your rights after Brexit. Many of you, probably most of you, will now have already applied for settled status, and the latest figures show that 4.8, nearly 5 million people have already applied. Oddly, that's higher than the UK government's estimate of the EU population, so statistics don't always tell the truth. I'm going to speak very briefly about settled status, really issues that have arisen recently. I'll also talk briefly about nationality. That's a large subject. We have done a previous talk devoted to becoming a British national. That information is on our website. We hope to do that again. So again, what I'm going to do is talk about some issues that have arisen recently, particular problems with the application process. And then finally, we're going to talk about what is the result of Brexit for you in the UK with your settled status. We're obviously talking about EU citizens, but we're also talking about citizens of 4 other countries. And those are citizens of the European Economic Area, the so-called EEA, and those are citizens of Norway, Iceland and Liechtenstein. There's also Switzerland, because there was an agreement between the EU and Switzerland, and there is now a replacement agreement between the UK and Switzerland. So we're talking the EU plus those 4 countries. We're also talking about family members of citizens of those countries, because of course those family members may not themselves be European citizens. They might be Japanese, for example, or Australian or American. Okay, so those are the people we're talking about. I'll first talk about question of nationality for children. Some children will be already British, and we won't have time to deal with that. Most children of, I'm going to say EU rather than EU, EEA and Switzerland, because in our experience, well over 98% of the people who are at these sessions will be EU citizens or their family members. In the case of children who want to become British, there's 2 routes. The main one is a child who is born in the UK and under 18. Now, in this case, the child can register. It's much more simple procedure than naturalisation, which is the name of the process for adults. So a child born in the UK under 18 can register to become British in the following circumstances, roughly where the position of the parent changes, where the position the parent gains nationality or long-term residence. So they are where one or both parents obtain settled status, which of course most of you will have. To emphasise, that means full settled status and not pre-settled status. As you know, pre-settled status is temporary residence. After 5 years in the UK, you can convert that to full settled status. Secondly, if one or both parents become British. Thirdly, and this will affect quite a few of you, if one or both parents obtain indefinite leave to remain. And then finally, if one or both parents obtain a permanent right of residence. Those 2 last categories are not likely to be in practice important because permanent right of residence still requires you to get settled status. Indefinite leave to remain doesn't require you to apply for settled status, but we advise it's probably better to apply for settled status briefly, because indefinite leave to remain is lost by 2 years out of the United Kingdom. Settled status is better because it's only lost by 5 years out of the UK. So very roughly, if one or both parents becomes British or gets settled status, the child has been born in the UK, the child is under 18, and the child can register to become British. There is another route, which is, in our experience, less common. And this is where a child was born in the UK and lived here until at least the age of 10. Absences for holidays are allowed. In fact, absences of 3 months a year are allowed. Now, the advantage of this route, although in our experience the less common one, is that the child, then the adult, can apply over 18. So the first route, where the parent gets British citizenship or residence, the application has to be under 18. In the second case, where the child was born in the UK, has lived here at least 10 years, the application can be made over 18. Now, the reason for mentioning this here on recent developments is, as you probably know if you've come to a previous webinar or read our materials or got advice, is there is a large fee of over £1,000, and there was a court case to decide if the fee was legal. That doesn't necessarily mean that the argument is that the fee should be abolished. It might be reduced, but the argument was that the fee was far too high. Now, that court case was heard by our Court of Appeal on the 6th of October last year, and although on our last webinar we said we hope to have a decision in January, when I checked last night in making sure my notes were up to date, there is still no decision. So if you have are considering registering your child as a British citizen, you have, of course, to meet the rules that we've just gone through. What we suggest you do is perhaps contact us at the end of February. We normally get news when a court case is going to be announced. I don't think that's going to be in the next few weeks. So you might want to contact us. We'll give you our contact details at the end of the talk. The other thing I'd like to say is, again, briefly, is just talk about some points about adults becoming a British citizen. This first point can apply to children as well. Now, we're often asked, what are the advantages and disadvantages of becoming a British citizen? Now, the disadvantage is really going to affect people who cannot have what's called dual nationality. That's where the country of which you're a citizen, under its law, that's not British law, doesn't allow you to hold 2 or more nationalities. Some EU countries, EEA countries, do allow dual nationality, some don't, and some do in certain cases. So you need to check. We're not experts on foreign law, so we can't advise on this. So the main point to consider is that if your country does not allow dual nationality completely, and you apply and obtain British citizenship, then of course you're not a national of what might be your country of birth. Usually will be your country of birth. And surprisingly, you then will not have free movement. That's quite well known, but you won't even have a right to freely move as a visitor. The arrangements, which we're not going to go into detail tonight, the arrangements for visits between the UK and the EU are broadly that British citizens will be allowed to enter as visitors for a 3-month period in any period of 6 months. So a point to be considered, it doesn't mean once you lose your nationality that you can still remain lawfully in your home country. So you need really to consider the question of your nationality. So let's assume that that's not your concern, or your country does allow dual nationality. Well, Most British rights are to do with residence, actually, rather than nationality, but there are really four advantages to British citizen. One is the right to vote. That is slightly complicated. So citizens of what's called Commonwealth countries, countries that used to be in the British Empire, and there are three in the EU, that's the Republic of Ireland, Malta and Cyprus. Citizens of those countries can vote in UK national elections. In local elections, the position is complicated. I'll just read my note, but I'm not going to go into detail. So citizens, EU citizens, are allowed to vote in local elections in Scotland and Wales, but in England it depends on your nationality. At the moment, there are agreements, not particularly important in the case of Cyprus and Malta, with Portugal, Luxembourg, Spain, and Poland. So for those nationals, you can vote in local elections. I got my local council election form a couple of days ago, and of course it does ask for your nationality for this reason. So your local council will check whether you have a right to vote in local elections. Now, this position is changing regularly. So when we eventually have our local elections in London, you may wish to check either with your local town hall or with your embassy. This is not an EU matter. It depends on the UK negotiating with each individual former partner in the EU. The other advantage to British citizenship, we've already said that settled status is only lost by 5 years absence from the UK. British citizenship is not lost by 5 years absence. It can only be lost in the case of serious terrorism offences, and even then only when you don't risk becoming stateless. So in practice, you're not going to lose British citizenship. You could join the armed forces and work for the civil service, which might be an issue for young people. So those are the main advantages. Disadvantages, just to repeat, really are to do with those people who cannot hold more than one nationality. The one issue I'm going to look at for naturalisation, the process of applying to become British if you're an adult, is the question of something called comprehensive sickness insurance. This causes a lot of worry. There has been quite a bit of discussion on the internet. If you're not aware of this issue, I'll just very briefly talk about it, and then I'll say why it's being greatly exaggerated. When the settled status scheme was set up, a lot of the government information on the internet suggested that EU citizens could apply to become British citizens 1 year after getting settled status. In fact, you can apply immediately if your husband, wife or civil partner is a British citizen. But for most people, the information was you could apply after a year. Obviously, you would have to follow the ordinary rules that apply to citizens from Japan or Australia or America or anywhere else. That, of course, goes without saying. However, towards the middle of last year, it was revealed that, in fact, the government were insisting that EU citizens were technically lawfully here prior to making the application. Now, in reality, EU citizens didn't have to worry about technicalities prior to Brexit. The EU treaties talked about people working, being self-employed, being students, being self-supporting, and a lot of other categories. So it is possible that you might have a period when you were technically not lawfully in the UK or in any other EU country. And that in reality didn't matter, that nobody forced people to leave through technicalities. Now, unfortunately, the department dealing with naturalisation applications, what's called our Home Office, are now applying the law quite rigidly, and they're saying that EU citizens have to be in the UK for a period of time and under the treaties. So that's roughly what it amounts to. And in the particular problem is that if somebody is self-supporting, so if they're living, for example, on their savings, then they technically you should have something called comprehensive sickness insurance. That's sickness that covers everything. And oddly, it's not enough that you could actually use the NHS. The courts have decided that it doesn't meet the requirement for sickness insurance that you could actually access the NHS. So it seems like a very big problem. However, it doesn't apply to people working or self-employed. It will therefore only apply to when people are not working. They, for example, living on savings. It won't necessarily apply if people are living on state benefits, because the free movement rights include somebody who's been, for example, made redundant, claiming benefits in the state in which they're working. So for a lot of people it won't apply because they are covered by the treaties. But it also won't apply to a lot of people who've got some kind of status. Now let's just look at those. So what the government are looking at is they're looking back over the last 10 years. So that's not 5 years that many of you will expect. Or if you arrive later, they're looking at the period from your arrival. But in addition to not applying if you've been working or in many cases claiming benefits, it won't apply at all for any period when you had indefinite leave to remain. That's quite an old category now. It hasn't been given by the UK government since 2006. Any period when you had either pre-settled or settled status, which you could have had for nearly 2 years now. If you had, again, the old permanent right of residence document, note that will say permanent. The British government gave lots of different cards out. Many of them had the word residence, but we're talking about the one that says permanent. And then finally, if you worked for 5 years continuously, or you were looking for work after that period, again, none of these rules apply. And they also don't apply to family members, not usually in the case of marriage to a British citizen, but family members of EU citizens. So now that sounds very complicated. Please don't try and remember this. All this information is available on our website. And of course, probably better, we can advise on this. What I'm trying to emphasize is this, what seemed to be a big problem, is in reality is not. Since it arose from the middle of 2020, of the inquiries we've probably had a few dozen. There was only one case where this was a problem, and in that case, the gentleman really had to wait between 1 and 2 years at most. The reason is because once he had his settled status, he was doing something before that. None of that period mattered, so it was just a period 3 or 4 years ago. So please do not get overly worried. The government guidance do say they will exercise discretion. The difficulty is they don't say what the discretion is. They don't say, for example, if you were living on your savings, that could be living on somebody else's savings, that they will disregard a certain period. It's not clear. There is a lot of campaigning to get rid of this rule, but at the moment it is there. So just to emphasize, please don't overly worry. It's probably best if we don't ask any more than perhaps one question about this in the question and answers. People get overly worried, and the difficulty is to advise properly. We need the detail. We need the detail of your circumstances. So let's then come on to any sort of issues with settled status. I'm not going to go through the procedure because again it's quite lengthy, simple, but it's quite lengthy to talk about. And again, a lot of you, I would say the vast majority of you, will now have applied. So just going to talk about any sort of issues. So just a reminder, and this is really for you who have applied, really to pass on to your any friends you have who of course may not live in Richmond. So settled status, EU citizens, EEA citizens and Swiss citizens must apply for settled status, and that includes children. We sometimes get people saying, of course I don't have to apply for a very young child. Yes, you do. The three exceptions are if you've already become British. We would advise, if you have applied recently to become British, to still apply for settled status. The application is free, and the reason is because applications to become British before the virus took around 6 months. They are likely to take longer now, and there is therefore no guarantee that you will receive a decision by the cut-off date of the 30th of June. So just to be safe, I'm not saying because your application will be refused, but there might be delay beyond June. So it's safer if you apply for settled status. Second category is citizens of the Irish Republic do not need to apply for settled status. There is a special agreement between the UK and the Republic of Ireland, which effectively allows the old free movement to apply. So Irish citizens can work freely. If you like, they automatically have settled status. And then finally, probably the largest category, although the numbers again are quite small, if you have the old indefinite leave to remain, and you will have applied for it. So if you didn't apply to the Home Office for anything, you haven't got it. It was only granted up to 2006. So again, if you didn't apply for anything before that date, you haven't got it. If you arrived since 2006, you haven't got it. The confusing point is you might have a card, you might have a stamp in a passport. If you don't have your old passport, you might have a very old letter. I advised somebody a few days ago who had a letter and a very old passport with a stamp saying she had indefinite leave to remain, dated 1978. So very, very old. Now, it is correct that people with indefinite leave to remain do not have to apply for settled status. We would advise you do, simply because you're going to have your indefinite leave to remain in old documents or letters. These can easily be lost. There is no guarantee that the Home Office will have a record. There were big scandals in the 1990s where hundreds of thousands of records were lost. Frankly, there's no guarantee the Home Office will have a record before computerization. So that doesn't mean, by the way, you have anything to worry about. If you have your documents, you're okay. The Home Office, in the case of non-EU citizens, regularly is asked, I've lost my documents, can you confirm I have settled status? They call it indefinite leave to remain. And the Home Office then asks you for proof, basically, documents to show you've been here a long time. So if you lose the documents, it's not a difficulty, but it can cause inconvenience. Under the settled status scheme, there is a government record, and although you're not issued with a card, which I'll come to in a second, the record is going to be more secure. You will, of course, as you know, get an email and you'll get a letter attached that you can print out. So it'll be more up to date and more secure. But again, you don't have to apply for settled status if you have indefinite leave to remain. So what's the effect of settled status? Well, it's really jargon for residence. So you have a right to reside in the UK indefinitely, and of course you continue to have a right to work as you previously did. So the only difference is that settled status is lost by 5 years absence from the UK. And to repeat, it's better than indefinitely to remain. So not only do you have a more secure record and a more recent record, but indefinitely to remain is lost by 2 years absence from the UK, which is not very long. So settled status gives you full access to UK benefits and public housing, exactly the same way as British citizens. Pre-settled status by itself doesn't give full access to UK benefits and public housing. This is a complicated area because the emphasis is by itself. So if you have a stamp saying you have pre-settled status, there are then further questions to go through. And very roughly, that means have you recently worked or are you working now? That's approximately what it means. There is a court case about this, but this has not been decided. So it's not clear at the moment whether the courts will find that pre-settled status by itself, so without any economic activity, does give you full rights in the UK. That is still going on. So if you have pre-settled status and you're not sure what your entitlements are, again, we can of course advise on that. And then I'd like to talk, we're getting more inquiries about this. As most of you will know, the right to apply for settled status applies only to EU citizens who were in the UK by, it's actually 11 o'clock on the 31st of December 2020. So that's the cut-off, although you have longer to apply. You have until June to apply. So you might have family members who are outside the UK. So the question is, can you bring them into the UK? And there are rules which allow a lot of family members to join you. And we'll just spend a bit of time on this. So if you have settled status, you can bring in what's called existing close family members. So existing means you have to have an existing relationship. Okay? So you meet somebody and marry them or form an unmarried relationship, that's not sufficient. You may have a right of entry to the UK, but these will be under the much less generous UK rules that apply to anybody else. Again, we won't have time to go through those, we can advise them. So if you have an existing family member, they may be able to enter the UK relatively easily. And the categories are really close family is really self-evident, are spouse, civil partner, unmarried partner, subject to test, of course, of the relationship. Usually means that you've known each other for at least 2 years. A child or grandchild. And now, child or grandchild, usually child, can be under 21, so that's not 18. And I yesterday had an inquiry from a father who was quite surprised that his child, who went to school with his former wife in France, could actually join him. So he's got the settled status. Obviously, their relationship was formed before Brexit, before the end of December 2020. The child is under 21, so the child can join him. A child or a grandchild over that age of 21 can join if they're dependent. That's likely to mean substantially maintained. So if you are a parent supporting, for example, a child at school or university in an EU state, then they are your dependent. Slightly more complicated with the child is living on more than one source of income, but we can advise on that. Again, in the case of parents, a parent who is dependent, so there's no right to bring a parent or grandparent in, but if you have a parent that you're supporting in an EU state, then the parent has a right to join you here. In the case of children born or adopted, it doesn't matter whether the child is born or adopted after the cut-off date. They can enter at any time. And briefly, what the family member needs to do is to apply for, it's called an EU settlement scheme family permit. Okay, so it's EU family permit. The ordinary family permit applies to people from outside the EU. Again, we can advise on the details of this. So those are the requirements. There are no other requirements that some of you will know that apply to non-EU citizens, such as language and income tests. So just a word then about proving settled status, which is again another question we're asked a lot about. So when you get your decision, that can be, of course, pre-settled status or full settled status. The Home Office will email you with the outcome, and you get a letter attached, which you can print out, and that is, you can keep that. So if you're successful, the strict proof is the online, is the computer record, if you like, the government database of your status. The government are not issuing residence cards to EU citizens, although oddly they are to the non-EU family members. There was a vote in our parliament 2 months ago, and I'm afraid that was lost, and the government are not intending to issue a residence card. It's not discrimination against EU citizens. They are planning to move everyone. People given a right to enter from Hong Kong, the same thing will apply, and EU family members who are not EU citizens, again, they will be taken off their residence cards eventually when they expire. Landlords and employers, because again, many of you will know by law, landlords and employers have to check on immigration status, and that's not just immigration status of EU citizens, it's everyone. They are told that they should accept a passport or identity card until the end of June 2021, the end of June 2021. For public bodies, in our experience, public bodies are accepting the printout of the letter you receive by email. We regularly deal with the local council here, and certainly they are accepting that letter, and they're not requiring somebody to go into the government database and prove their status that way around. It's unlikely that employers or landlords will do that. In fact, they're not supposed to accept letters. They're supposed to check the government database. But certainly until June, they are advised that they should not be asking for proof of settled status. They should be just checking your nationality. The deadline for settled status, again, this causes a lot of worry. Now, in the law, it says that the deadline for EU citizens, and again EEA nationals and Swiss citizens, to apply for settled status is the 30th of June, midnight 30th of June 2021 this year. So 4 months time, 5 months time. At the moment, we and the Richmond Council scanning service are closed. The reason for mentioning that is some people will need help with their applications. Many of the people we advise, we can advise by email, by phone, and we can advise them what to do. But some people will need help, particularly with the first part. As many of you will know, the first part, you have to scan your passport, you have to take a scan of your face, you have to take a selfie, a photograph, and then you do the application, the form online. And many people will need personal help. So it's not possible, particularly with the scanning part, where we need to be close to somebody. It's not possible to do that at the moment. So a lot of people are getting very worried about what happens if they miss the deadline. Now, I wrote letters to all the people I'm advising in this position today, And first, I hope that the advice centres do reopen as soon as possible, but I think, frankly, it's probably not likely for the next month or two. Now, the government announced in December that they will accept late applications if there are reasonable grounds. Okay, so that's in law, if you like. Didn't get much publicity, but it's binding. Now, it doesn't mean you can just put off the application. You will have to give reasons. But clearly, if somebody cannot do the application without getting assistance, then they have reasonable grounds. So certainly anybody in that position, and you might know people outside Richmond, you might have friends or family, and it's impossible, they may not have the computer skills to do the application in time. Tell them, please not worry. On the other hand, don't delay. If things do reopen, get advice. But if unfortunately this present shutdown continues, it will be possible to make a late application. You have to do it as soon as you can. You can't wait 3 years. But the government will accept late applications. That is a recent change. And then finally, I'm going to go through some sort of effects of Brexit, and they're really a sort of mix of things. And some of these things have been around some time, and some are quite new. So we'll go through some sort of various effects of Brexit. The first one is very new. As you probably know, the negotiations over mostly the trade agreement went almost to the last second. I think they were finished about 2 days in time at the end of last year, and that there was an agreement. Most of this is all about trade and complicated things like taxes, so it doesn't actually apply to people. But as part of that agreement, the EU UK agreed that the existing EHIC, so that's the European Health Insurance Card, would continue. So that means if you've got an EHIC already, you could use that. And many of you will know the EHIC covers you for short-term visits to other EU states. And that's because the free movement doesn't actually say anything about visiting. So you go on holiday, you are covered in another EU state. Now, when the existing card expires, so you've got a card, you can carry on using, that's fine, you don't have to renew it. Once the existing card expires, it's going to be replaced in the UK by something called a GHIC, a global health insurance card. The UK government wanted to remove European. It's very few countries outside the EU have visiting health arrangements, but any case, so the government are going to change the name, but the effect will be the same. So once your EHIC expires, then you will apply for a GHIC, a global health insurance card. One point to note, that's issued by where you live. So you will be applying to the UK government. It doesn't matter whether you've become a UK citizen or whether you've just got your settled status and you carry on with your own nationality. So you don't have to apply to your home country. The application is dealt with by where you live. So it's issued to UK residents, which will include everyone with settled status and also pre-settled status, by the way. Now, this is one of the very few points where there is a distinction between the EU and the other countries I mentioned, the other 4 countries. At the moment, slightly fiddly exemptions, particularly for Norway. But at the moment, generally, you will not be covered by the EHIC or the GHIC for visits to Switzerland, Norway, Iceland, Liechtenstein. That may change, but it does depend on UK negotiations with those countries. So the negotiations with the EU are finished. This is completely separate. There are likely to be negotiations. We hope that the agreement will be made on mutual health use of each other's health services. But at the moment, you need to be careful. So if you're travelling to countries which you think are you see as European, but they're not actually in the EEA, then please check first. The position might change. So that's sort of health, and again, I haven't put it in the notes, but people do ask, you know, after Brexit, do I have access to the NHS? The answer is you do, because NHS access, and I mean by that hospitals, you have a right to sign up with a GP anyway. Access to hospital treatment is covered by residents, so it's you have to be basically living in the UK. You clearly are living in the UK. That's not an issue. You have perfect right to continue having access to the NHS for treatment. And then just a quick word about students. EU students with settled status or pre-settled status. Again, this was decided really the autumn, so quite recently, do pay UK fees. So there's a lower rate of university fees for UK students. So EU students with settled or pre-settled status, which will cover the vast majority of EU students who are in the UK, very few have not applied. They are entitled to UK fees. It doesn't matter when the course starts. Now, what about the position of EU students? So they're not living in the UK, so students from another EU country. And of course, many of you will have friends or family in your home country, in another, obviously not in the UK, and they may not wish to join you in the UK if they're close family members. Well, the position is that courses starting up until July, so quite soon, pay, and that's the end of July, pay UK fees. So courses starting after that, courses dated with the first date of the courses after the end of July, then you will be paying foreign student fees. Okay, so there is a distinction between EU students who are in the UK and EU students coming to the UK. I've already mentioned that you as EU citizens will be resident. It doesn't really matter whether you have settled status or pre-settled status. You have to apply for it, but at the moment you're a resident because you're living here, and therefore you have access to the NHS. Again, we get asked a lot of questions about pensions, and the position is there is no change with pensions. Private pensions are contracts, and it doesn't matter. You know, Brexit makes no difference. You can draw, you can take your pension wherever you're living. So that's private pensions. State pensions, public pensions. There are arrangements, and there were arrangements before Brexit. There are arrangements with the EU states to make sure that you don't lose out by movement. For example, the UK pension requires a certain amount of payment of national insurance contributions. It's actually 30 years contributions. So the British government will take into account your social security contributions in all the other EU states and add them up. So you won't lose out. And the same way around, other EU states that you've lived and work in will calculate your pension. So again, you don't lose out. So movement will not badly affect you in respect of your pension. The other issue, which doesn't just affect EU nationals, is the question of the British state pension annual increase. Now, we have a peculiar position in the UK that if you retire and you start receiving your UK state pension, if you move to another country, that pension may or may not be increased. It depends on the country. While we were members of the EU, there was an agreement between all the EU states that if you move to another EU state, your pension would be covered by the same rules. So in the case of the UK, if you retired to Spain, or if you retired to your home country, if that was not Spain, you would receive your British pension, and you would receive the increase, the annual increase that people living in the UK receive. Again, as part of the recent agreement, that has now been extended indefinitely, which means that if you return to your home country or you move to another EU state, and of course you have the right of free movement, so long as you don't lose your nationality by becoming British, then you will receive the annual increase that British pensioners receive. Now, just as I come to the end, I'd just like to draw your attention briefly to some sources of information. You can, of course, and we would like you to contact us with any questions, because there's obviously going to be a limit tonight. Many of you will have questions with some detail or perhaps personal circumstances that you don't want to discuss publicly. You can contact us by phone. The phone number is on the slide, and it's on our website, Monday to Friday, 10 to 4. We're receiving a lot of phone calls at the moment, and you will find that the best means to contact us, and the best means to contact me, is actually by email. And there is a form on our website, and you can put as much detail as you want, which I like, because then when I contact you, phone you or email you, I've got all the information, and I then can answer most of the inquiry, or at least I've got the basics. We also issue updates, so some of the information you've heard tonight is quite recent. And I'll be issuing in the next few days another update with most of the information you've heard tonight. And you can sign up for that. There's no charge. We don't fill up your email box. This is generally once a month. And it's a good way of finding out what's happening. You can also receive email updates from government. I have to say, we are signed up to this, and we haven't actually received any email updates from the government for many months. So you can choose whether you receive your updates from us or the government. There's very good information on the government website about the detailed rules about becoming a British citizen. Again, we haven't gone into those. What I've looked at are the particular problems and issues that affect EU and EEA and Swiss citizens. But the detailed rules about, language rules and things like that are all on the government website, and they're very clear. And I would advise anybody thinking about applying for British nationality to look at that website first, and probably helpful if you want advice, look at the website first, because then many of your questions will be answered. There's also very good information. This is not actually on the government website. There's a law centre called the Children's Legal Centre, which is very good. And I think their information on registering a child as a British citizen is much clearer than the government information. So that's the reason I've given you two different sources of information.
As you know, we invited Councillor Gareth Roberts, the leader of Richmond Council, to attend this evening, and he was actually at the start of the meeting, but we had some technical problems, so he wasn't able to actually do any welcome words. But he has sent me a message that he's asked me to read out to everyone at the meeting this evening. So, good evening, everybody. Please accept my apologies that I wasn't able to join you earlier this evening. I was all set to go and then had some technical issues. I very much hope you found the presentation useful and came away with the answers that you needed. I know this is a difficult and often troubling time for many of you. However, I also know that the team from Citizens Advice have been able to offer help, insight and reassurance to many residents in the borough. Please do be assured that although we have left the EU, nevertheless those EU27 nationals who have chosen to make their home here in Richmond are valued and welcome. That is why we are so pleased to work with Citizens Advice Richmond to put on events such as this to ensure you have every assistance that we can offer. With very best wishes, Councillor Gareth Roberts, Leader of Richmond Council. Thank you very much, and I'll now hand over to my colleague Bradley.
So the first one, Mike, is my family and I have pre-settled status. We came to the UK in 2018. What are our options to stay in the UK?
Oh, well, that's actually a very straightforward question, but again, it is a good question. You have pre-settled status, so if you like, that's temporary residence. And after 5 years in the UK, so that will of course be sometime in 2023, depending on the exact date you arrived, you can apply for full settled status. The application is likely to be very similar. Obviously, the process might change in a few years' time, but it's likely to be very similar. In fact, it's actually simpler. Now, the one thing to be careful about is you are, of course, allowed holidays. And in fact, you are allowed up to 6 months, so it's quite good, out of the UK in any of the 5 years before your application. So if I can just sort of pin that down. Suppose the 5 years run out in August 2023. Then if you take all the years from August to August, you are allowed to be out of the UK for 6 months in any August to August year. Now, nobody is travelling at the moment, so really 2018 is 2021, that's 3 years. So what you have to be careful about, because we regularly get questions for people who've got to important reasons for leaving the UK, is be careful about your absences. Now, one thing I should say is the rules do say that you're allowed actually 1 year, so 1 complete year, for special reasons. Now, the difficulty is that and this is not just the British being difficult, the EU law has the same wording. It's not actually defined. There are no sort of court cases about this yet. Now, certainly, if you have you're caring, for example, for an elderly relation who's ill, that would certainly be a good reason. The government on the question of nationality are being very much freer with COVID-related absences. Again, in certain circumstances, people cannot travel. They may have difficulties travelling. That may be another reason. Probably not by itself, because it's unlikely you will be not able to travel for 1 year. But for example, if you were working or visiting for 6 months, you then couldn't return for a month or two, so that takes you over 6 months. Then clearly you have a good reason of more than 6 months to a year. So you have to be careful really about trying not to be absent for more than 6 months in every year. And I would say if you've got a reason, and most of the people we've spoken to have very good reason, they're usually to do with serious illness in the family, for being out of the UK for longer than that, then please get advice. But you are lawfully in the UK. You can continue to work in the UK. It just means that you do have to remember, you do have to upgrade. I'm afraid it's not automatic. You do have to upgrade. So once you've been here 5 years in the UK, then you apply for full settled status, and then you don't have to do anything. That's only lost if you leave for 5 years.
How will the online proof of settled status work in practice? So how will it be checked when entering the UK via airports, etc.?
Yes, actually, this is there's a lot of worry about this, and frankly, it's very difficult to advise because it's quite early. I mean, the scheme has only been going for just over 18 months. I don't honestly think that airports are going to be a difficulty because in the case of employers and landlords, you are going to have to, in fact, you're going to have to get into the records. The government have access to the records, and they've given access to the immigration authorities. So, if you are stopped, then the immigration officer will they'll ask your name and address and date of birth, possibly national insurance number, and they will then be able to access your records, and that will show whether you have pre-settled status or settled status. So I don't honestly think, if people worry a lot, I would say take your letter that you get, your emailed letter, so it's an attachment to an email, and that confirms your position. But in reality, it's only if all the government computers go down. Of course, these things happen, but it's quite rare. So I don't honestly think the question of entry to the country is going to be an issue. Might be more of an issue if there are problems with computer checks and there is a very short deadline to accept a job or rented property. There are no immigration checks, by the way, in buying houses or buying flats. That's a different issue. So, to answer the question, it's probably too early, but I don't honestly think that there's going to be any issue with entry through the airports, because the government has said it's going to move away from cards, and there are no longer stamps and passports. So for things like people here on student visas, work visas who are not EU nationals, exactly the same thing will apply. They're moving away from cards. I don't know why, but they are. So everything is going to be computerized. So I might be wrong, but I don't honestly think the airport is going to be an issue, because simply because the government will be able to get into your records.
I cannot find the proof of the settled status email that I received. How can I get a copy of that?
Well, I mean, you should have received an email. Of course, it might be deleted. The other thing is go into your account. And I mean, you can contact us if you have problems doing that. There is a help number, and it's sadly not in the slides. I'm sorry about that. But if you type in EU settled status scheme in Google and click on how to apply, there is a government helpline, and they answer incredibly quickly for any government. We regularly phone them. I mean, the difficulty is we can't actually phone on your behalf because we have to have you with us, and we are not open at the moment. So I would say, try to go into your account. If you can't do that, call the government helpline, and they won't go into the account for you, but they'll tell you what to do. They'll tell you what to do. So you should be able to access it. So that will tell you it's there. It is there. They haven't lost these records. And then the other thing is, print out, once you've gone into the application, it will say you have been granted settled status, brackets, indefinite leave to remain. It's the same thing. That you can then print that out, but please don't worry. It is straightforward. It's not complicated. You type in your details and you will find them. So try after this or tomorrow, and if not, go to EU settled status, click on that, and then how to apply, and then there is a government helpline which is open very, very long hours. They answer very quickly. They're also very, very helpful.
This one is, I'm an Irish citizen and my family are non-EU citizens.
Yeah.
They have applied for settled status, but there seems to have been quite severe delays. Would my applying for settled status speed up the process?
No, I don't think it would make any difference. We probably need a bit more information on this. I don't know whether, is it possible that the questioner could type how long the delay is? Could we ask the questioner just to say roughly when the family applied, approximately, just roughly? Was it 2 months ago? Was it 6 months ago?
You have just asked the question, but if I do get a response, we'll come back to be able to answer it.
Okay, well, look, I mean, let me try and give some answers. So, I mean, the questioner is perfectly right. Because they are an Irish citizen does not mean that the family do not need to apply, because, of course, well, unless the family are Irish citizens, but I think the suggestion is that the family are not Irish citizens, so they need to apply because they are. The questioner is an EU citizen, and they are family members, so they are the sort of people who have to apply. So they have applied, but there has been delay. Now, it is right that the virus has affected everybody, and it has slowed down applications. It used to be in the early part, up to the early part of last year, decisions were coming through in 2 to 4 weeks, so pretty quickly. I think the question is suggesting longer. Now we don't know how much longer. Certainly more than a few months would be surprisingly long. So if I can suggest exactly the same thing to the previous questioner, that that you call the EU helpline. It's useful if you have the reference number. It's quicker if you have the reference number for the people in the family who applied, and they should be able to tell you, is the delay, is the delay lengthy? Is it longer than you expect? If you're not happy about that, can you contact us? If we believe the delay is very lengthy, then we will suggest one of the local MPs contacts the Home Office. We wouldn't suggest you do that if the delay is less than 2 months. Things are getting longer, unfortunately, but and sometimes coming through us, you can of course contact your MP direct if you wish. So try with the helpline first, have the reference number ready, ask them, how long are applications taking when they were put in on this date, and if they can't tell you when you should get a decision, then contact us. As I say, the best way is email, and then I will call you, we'll discuss it in detail, and then we will either contact the Home Office ourselves or ask an MP to help.
So it covers our next question as well, which was how long was it taking for approval of applications at the moment?
It's actually, I can't say. That may sound like a terrible thing when you're giving a talk like this, and the reason is it's actually been quite a long time, some months now, since we've had people who contacted us and just put an application in. So a lot of the cases we know decisions were made were before the autumn. And then as the deadline came along, we got a lot of inquiries in October, but the number of inquiries about settled status have actually gone down a lot. They're mostly actually about nationality and rights in the UK, which is the reason I didn't spend too much time on settled status. So I'm sorry, I cannot say. I would certainly say low months, shouldn't be very long. Without addressing the questioner, the cases where the applicant has some criminal convictions can make the application process very long, because they're passed to a completely different department, and in those cases they can take extremely long. Just in case you have people who have got criminal convictions, I don't mean minor motoring offences, it would be wise to get advice. There is a right of appeal under the scheme, but this is not something we can deal with, but we'll gladly try to put the person concerned, we'll give them details of specialist solicitors, so if unfortunately their application is refused, then they can appeal. So I'm sorry, I can't answer that question, but I think, honestly, I would say as a rule of thumb, if you put an application in and you hadn't had a decision, you'll get an acknowledgement, but if you had not had a decision in 3 months, please contact us.
The original query on the Irish applicant was applied for on the 5th of November, so the advice would stay the same.
Yes, I'm afraid, well, December, January, February. Yes, I mean, look, give it. Could you contact me, because I'm actually on holiday next week? Could you contact me if you haven't heard in 2 weeks, and then we'll discuss it then, because that even with Christmas, that's that's close to 3 months. So please contact me if you could use the email form. It's quicker, and if you could avoid next week, because you won't get an answer. If you could contact me first week in February, and that's then I can then say it's 3 months. If I'm complaining about the delay. So please contact me then. Thank you.
We've had a couple of queries regarding ID for the application. This specific query was about the passport has expired and the family will have difficulties getting it renewed. How can they apply for settled status without a valid photo ID?
That is difficult. Again, you see, it's quite difficult answering questions without knowing the particular facts. I don't know if the questioner is able to say, what are, because a lot of embassies are saying there are problems, but they're not actually giving the time scale. So it does cause great difficulty proving identity. You can, but the government don't like it. And in fact, I can actually answer this. I phoned the helpline about this just before Christmas, and I was told really quite politely but firmly that you really must do your best to continue contacting your embassy. And if it gets close, I would say May, and there's still no word on the renewal of your passport, then what you have to do, you can't use the online version. You have to phone up for a paper form, and then you have to send in documents which to show. Obviously the expired passport may be one, but of course the expired passport may be with your embassy. So at the moment the information I have is the government are not saying I'm told there are delays. Just being told there may be delays renewing your passport is not going to be enough. They will insist on a valid, that means up-to-date passport or identity card, but they will accept alternatives, but only if there's still problems with the passport close to the deadlines. I'm afraid, I would say if there's still a problem in May, contact us and we will tell you the latest position. We get a lot of information direct to us that's not always available to the public. I'm sorry, that's all I can say on that one.
Sorry, and there's been a couple of other questions which I've not translated over to slides yet, but concerns about the
slides. Sorry.
Oh, sorry. Concerns in regards to using the app. So we've had issues with scanning passports. Dutch passports were the ones in question on that particular question, and some concerns about if you can't scan the documents, is there any way else you can deal with it without having to post it in for the application?
Right, yeah, not an easy one. So this procedure is great if it works well. I do sympathise with the questioner because we tend to restrict our help with the actual applications because they take quite a long while to people who are well over retirement age, usually over 70. And in many cases, it has taken, literally dozens of times to scan the passport, even though we know it's valid. We know it's the modern biometric passport that has a box on the front, a rectangle box. So we know it's a valid passport. We check the client's details. We know they match. There should be no problem reading the passport, but there is. So on the first question, again, I would gladly try to help with this, but I'm sorry we're closed, and if we speak on the phone, I would, it's not going to help because you're doing this yourself. So I would again suggest, third time, that you call the EU helpline, so it's EU settlement scheme, how to apply, phone them. They may have suggestions. I suspect they probably sometimes they can suggest how to hold the passport. Sometimes that's useful. Now, if that doesn't work, I'm afraid, yes, you will need to send off your passport. So I think phone the helpline. If you still don't want to, and I understand that, I wouldn't want to send my passport in the post, and I have a British passport. You could contact us. We will help you, but it won't be at the moment. Now, again, just to go back, the government in December did announce that if people, do have good reasons for the application going beyond June, and we would hope it does not in your case or anybody else's cases, but just in case that happens, of course, if you're unable to do the scanning, you did need help. The places that we're helping, not just us, but Richmond Council also help with scanning. They are closed. Then you will have a good reason you'll be here lawfully. So try the helpline first. As I say, if that doesn't work, contact us. Our
next question is, will EU driving licenses still be valid in the UK?
They certainly are at the moment. I can't, I'm afraid, answer the question on expiry. As you know, you can lose a passport for medical reasons, driving license, medical reasons, and renewal after retirement. So your existing driving license is certainly valid. And your existing driving license is valid for, I can answer this, travelling to the EU. It's a more complicated question on insurance. The question about the driving license expiring, I won't be able to answer. I'm sorry about that. But if the question had sent me an email inquiry, which of course is going to be very short, I will of course check it, and that all these questions and answers will be on the website. So anybody else interested in the question of driving licenses, please just wait a week or so, and then the information should be on our website.
So the next one is a 14-year-old who was born in the UK, born outside of the UK, sorry, but lived in the UK since they were 1. What is the best route forward for that person?
Well, so first of all, the child must apply for settled status. The questioner hasn't said that either of the parents are British citizens, so I think we can accept that they're not. So, merely because the child has lived here for a long time, I'm advising somebody who's lived here from sort of 1 or 2, and he's now mid-30s, and he was very surprised that he does have to apply for settled status. So, the child in this case is no different from any other EU citizen. The fact they've lived here a long time is doesn't affect anything. So the simplest way is if the parents apply, child applies at the same time, and then the child will get, if the parents get, well, the child should get settled status if the child's been here for more than 5 years. And then, exactly the same rules apply if the child wants to become British. So if you think about it, so the child hasn't lived here for the first 10 years of their life. We know that because they're not for the first year. And the child wasn't born in the UK and their parents got something, settled status or British nationality. So they can't register. So what they have to do then is wait until they're 18. And if they want to become British, of course, they don't have to. And the child can then apply to naturalise. So this is really no different from really an adult. So the child does have to apply for settled status before June, unless there's a good reason. If the child wants to become British, the child will have to wait to 18 and then apply.
I have dual nationality. Can I vote in both countries' national elections?
I had to think about that for a second, but actually it's easy. The answer is yes. Well, I'm assuming, of course, that when the questioner says dual nationality, I'm assuming that they mean they are British and they have another nationality. I'm sorry about that. That was a very easy question. The answer is absolutely yes. In all elections in the UK.
I have British citizenship, but my retired mother has pre-settled status from 2019. Can she be treated by the NHS?
Yes, the answer is because we don't have a nationality test, and we don't even have a sort of long-term residence test for the NHS. So so long as you are your resident, which roughly means living permanently in the UK, then you have complete access to the NHS. And apart from the usual prescription charges, and your mother could be exempt from those, so get advice. She absolutely, there's no problem with her accessing the NHS. And just to emphasise, there's no difference between pre-settled status and settled status. If you're living in the UK, you have access to the NHS. Now, a lot of people may say, you know, this is can't be right. Well, the reason is some people who are here for a temporary period, but still living here, and those are really going to be people on work permits and students, so non-EU citizens. They have to pay some money. It's called the health levy, and then they can access the NHS. So they have to, if you like, make a payment in advance for the NHS. But in the case of an EU citizen, as I say, if you are here, you know, before the end of last year, and you're clearly continuing to live here, then you have access to the NHS. Now, the position is different, of course, for EU citizens who come now to work, because that's post-Brexit, but we're not talking about those people. So absolutely no problem. Your mother has access to the NHS, yes.
I have settled status, and I have had so for over a year.
Yes.
But I stopped working over 15 years ago in the UK and have been raising our family since then. Will this affect my naturalisation application?
Right. Sorry, the questioner has settled status, yes?
Has settled status and has had so for over 1 year.
1 year, okay. Right, so let's just look at these sort of ordinary rules for naturalisation, and then we'll talk about these sort of complications. So there's no reason, unless the questioner's got serious criminal convictions, why the questioner you know, shouldn't meet most of the rules. I'm not going to go through them all now, but I'm sure he or she knows about most of the rules. And usually you have to have settled status. And usually you have to wait 1 year. The exception is if you're married to a British citizen, you can apply immediately. Now, the complication is this question about, you know, what were you, the government go back 10 years, what were you doing in the last 10 years? Now, I'm not trying to dodge the question, it's a very interesting one, but I do need the detail. Because there are lots of exceptions. For example, you know, a woman on maternity leave, that's fine. Somebody who loses their job and they're redundant, and they claim it's not called unemployment benefit, but we call it that. That's absolutely fine. Somebody might have to give up work through sickness. That's fine. We've already said working, etc. So there's lots of exceptions. I would need detail. So if the questioner could email me, and really the important points are what happened in the last 10 years. So just the sort of history, and then you know, quite honestly, there might be a problem. But that doesn't mean that you can also apply for British citizenship. It might mean you've got to wait a bit. Hopefully not too long. The reason you want to be careful about applying for naturalisation is, okay, you're refused, you can apply again, but the fee is, I haven't got the exact figure, it's about £1,300. It's more than the child registration fee. And there are no court challenges to this, so nobody's arguing that fee is illegal. So it's a lot of money, and the government keep the fee. So that's the reason you have to be very careful applying for naturalisation if there's any difficulty. I advised somebody 2 days ago, I can't go into the details, but my advice is to be cautious. she probably should wait probably 1 or 2 years. Now, this wasn't the question, all this complicated business about what you were doing. This is actually absences in the UK, and this applies to Americans and Australians. It's not anything to do with EU citizens, but this person had quite lengthy absences. She had relatives abroad. There were good reasons, but they were over the rules. Now, we did look at the guidance. It's very long, and there was some discretion, but my view was it was probably dangerous, that she did risk losing the fee. So that reason, it was her decision, of course, but for that reason. So just very briefly, I do need more detail. It wouldn't be right to ask you publicly about your personal circumstances. So if you could send me an email, it's on the website. I'll hopefully try to go back to our information slides a bit while we're finishing, and then if you just send me your history in the UK in the last 10 years.
So our last question, Mike, is if I have settled status, can I still draw a state pension if I have been outside of the UK for more than 5 years, so i.e. retiring abroad?
Oh, absolutely, yes. Now that's actually a very good question. So when we say you lose, so I'm afraid, if you do go abroad, and by the way, you only need to return a couple of days, it would be wise, if you're thinking about going abroad and trying to retain your rights here, it's always wise, to be cautious. There's more sort of history about indefinite leave to remain where it's lost in 2 years, and I'm afraid that those are the rules. So people have been stopped at airports and asked, when were you last in the UK? Two and a bit years ago. I'm sorry, you can come here as a visitor, but you've lost your permanent residence. So it is right, you can return for a day or two. I would advise, because you might be asked questions about proving that to break the 5 years you return for a long holiday. So let's assume that the questioner has actually left the UK and they've gone to live elsewhere. They don't particularly want to come back, which is fine. So you lose your settled status, but that does not mean that anything else. All that is an immigration category. So it does not mean there's any effect at all on your state pension. Now, it doesn't mean, of course, that you can't get around the rules on the state pensions. They're quite complicated, but very roughly, the UK state pension is payable in full if you pay national insurance. That's our social security contributions for 30 years. Doesn't mean you've got to actually be working. There's lots of exceptions, bringing up young children, caring for someone. It's actually quite complicated, but so let's assume you've got your entitlement, so it might not be a full pension, and you're either receiving it or you're going to receive it in the future. Absolutely, yes. So once you've got your right to the pension and you live abroad, and then 5 years later you're able to receive it because you're now 66. That's our retirement age. Then you can apply for the state pension. You don't have to return to the UK to apply. So absolutely, it's a good question. The state pension is not lost if you lose settled status. Absolutely not. No. The Chief Executive, Simon Lawson, is going to say a few words.
So that's the end of our webinar this evening. Thanks very much to those who attended, and I hope that you have found it useful. Remember that although the webinar is finished now, we are still here for you. We have a special project to help EU citizens who live, work or study in the borough that is funded by Richmond Council. We can only offer advice by phone and email at the moment, but details about how to contact us and our opening hours are on our website at citizensadvicerichmond.org, and you'll see that on the slide behind me together with our telephone number. So you can still get advice if you need it, if we haven't been able to answer your questions, or if you have any other issues that arise in the future. You can also sign up to our mailing list, which will enable you to get updates on the settled status scheme, updates about future webinars and future events that we're going to be holding. So I'd like to finish off by thanking my colleague, thank you very much, my colleague Mike, for his expert presentation and expert answers to all your questions. I'd like to thank Bradley for moderating the questions, and my colleague David, who has worked tirelessly behind the scenes to keep the whole show on the road and keep everything together. And finally, I'd like to thank Councillor Gareth Roberts and Richmond Council, who have funded this project. Thank you very much, ladies and gentlemen, and good evening.